I will take questions at the end. I've reserved the last 15 minutes for questions. Please be advised, though, that I cannot give individual case advice. So when you ask a question, I'm going to be responding generally. So this is the general process. This is the general procedure. I do not advise you to, give details of your confidential case in this setting either, because you don't have any privacy and it wouldn't be confidential. If you have questions, please type them in the chat, and which is at the bottom of your screen with the message icon. It says chat, and Debbie will read them to me. I know that students also sent in questions regarding, various topics. My presentation today focuses only on how to get a green card and the various green card programs. So I will address those questions, and then if there's time, I will answer the other questions that people sent in that relate to optional practical training, citizenship, green card through marriage, specific to their case. Okay, now I will be sharing my screen so that you can follow along with the PowerPoint presentation. However, the school will be sending out the presentation after. So just give me a minute. Can everyone see the screen?
Yes.
Yes.
Yes, thank you.
Oh, okay. Okay. All right, so there are several bases for obtaining a green card. There are humanitarian programs, special programs by nationality or occupation. You can obtain a green card through family sponsorship, employer sponsorship, and self-sponsorship. This is where you do not need an employer. The first category we're going to discuss under the humanitarian programs that lead to a green card is asylum. This is where a person fears persecution on the basis of their race, religion, nationality, particular social group, or political opinion, should they return to their country of citizenship or country of last habitual residence for those who do not have citizenship. The person needs to apply within 1 year of entering, or if the application is based on changed circumstances, they need to apply within 1 year of those changed circumstances. If granted asylum, you can adjust your status to lawful permanent resident 1 year later. There is the T visa category. This visa is for victims of sex or labor trafficking. Sex trafficking is defined as any act, meaning transportation, recruitment, harboring, any act that commits or induces someone to engage in a commercial sex act by force, fraud, or coercion. If the person is a minor, you do not need force, fraud, or coercion. It's enough that they were induced to engage in a commercial sex act. Labor trafficking is, again, the recruitment, obtaining of anyone for the purpose of obtaining their labor or service through the use of force, fraud, or coercion for the purpose of involuntary servitude, peonage, debt bondage, or slavery. Meaning you're having them work and either you're paying them so low that they're involuntarily working, or you're not paying them at all, or telling them they need to work because they have to pay off a debt. A requirement for this visa is that the applicant has to assist law enforcement in the investigation or prosecution of the trafficking that they are a victim of. and they receive a temporary non-immigrant visa, which is valid for 4 years and allows them to work during those 4 years. And then they can adjust their status to a lawful permanent resident after 3 years. The next temporary visa that also leads to a green card is the U visa program. This program is reserved for victims of specified criminal activity. There are about 16 crimes, and then crimes related to those 16 crimes are also included. Most of the crimes are crimes against persons, like rape, murder, domestic violence, blackmail, stalking. But then there are also other crimes like witness tampering or fraud that could lead to a person being able to apply or being eligible for a U visa. The applicant must prove that they've suffered mental or physical harm. So if the act of the act for which the person has become a victim has traumatized that person, that could qualify as mental harm. If, say, a person was shot or raped, that could qualify as physical harm. The applicant must be helpful in the investigation or prosecution, and it is a requirement that the police or the courts or the prosecuting attorney certify that the applicant has been helpful. The crime has to have occurred in the United States, and after 3 years, the applicant is able to adjust status to lawful permanent resident. Again, the applicants are given a non-immigrant visa valid for 4 years, and they're also given work authorization. Another humanitarian program that leads to a green card are benefits under the Violence Against Women Act. This applies to males as well, even though the title of the law is Violence Against Women Act. To apply for any VAWA benefits, the victim has to prove that they have suffered battery or extreme cruelty committed by either a U.S. citizen spouse, former spouse, parent, or child, or a permanent resident spouse, former spouse, or parent. You can apply to adjust your status to a lawful permanent resident on the basis of the abuse. And this relief is also available if the person is being, if the government is attempting to deport this person and they've placed them in removal proceedings. In removal proceedings, the applicant can apply for adjustment of status to that of a lawful permanent resident, or can apply for what is called 3-year cancellation of removal. For cancellation of removal, the person has to prove they were in the US for 3 years and that they would suffer extreme hardship if they were deported or removed from the US. So that is how those humanitarian programs help. Now, there are other green card programs. Some are based on nationality and some are based on occupation or which employer the person worked for or will be working for. The Liberian Refugee Immigration Fairness Act grants lawful permanent resident to citizens of Liberia, spouses and children who of these Liberian residents, or I'm sorry, Liberian citizens. So if a spouse is not a Liberian, they can still benefit from this law. The same applies to the children of any Liberian who would qualify under the act. It applies to Liberians who were in the US as of November 20th of 2014. Then you have green cards for Afghans and Iraqis who were employed by the US government. You also have special immigrant juvenile status for persons who arrive in the United States while they're still a minor. Generally, it's if someone comes to the US without their parents while they're under 18, but some states, like Maryland, has extended eligibility to persons who arrive in the United States without their parents and they're under 21. If a person is coming to the US or will be working for an agency, for the US Agency for Global Media or in a grantee agency as a broadcaster, they qualify for a green card. All retired employees and family members of eligible international organizations or NATO also qualify for a green card. The next group of visas that lead to a green card are based on family sponsorship. You are considered an immediate relative if the relative sponsoring you is a spouse, parent, or child over 21 years old, and that person is a US citizen. Being an immediate relative means you do not have a wait. You do not have to wait for a visa, regardless of which country you're from, and regardless of whether other categories of persons from that country have a wait. Children have to be 21 years or older in order to petition for a parent. And only US citizens can petition for their parents. So that is the distinction between US citizens and permanent residents. Now, all others qualify for an immigrant visa under the preference category, meaning you have to wait for a visa. You have to wait until your priority date is current. The priority date is the date USCIS receives the application to classify you as someone eligible to receive an immigrant visa. So adult children over 21 years of age of a US citizen fall into that category. Spouses and unmarried children under 21 of permanent residents also fall into that category. Unmarried children of permanent residents over 21 years of age. A permanent resident cannot petition for a married child. And just because someone's in a preference category does not mean they have to wait for a visa, because right now, the spouses of permanent residents have no wait for a visa for many countries, except the ones that are usually backlogged, like India and China. The brothers and sisters of US citizens fall into the preference category, and they must wait sometimes from 10 to 20 something years. Married children of US citizens can be the beneficiary of a family immigrant visa petition, but there is a wait as well. The process for family sponsorship. The petitioning relative files an application. Their background is checked to make sure that they have not been convicted of any crimes that would make them a danger to someone else. Usually it's sex crimes that would render a person ineligible to petition for a relative. After the background check, if the relative is in the US, they would be scheduled for an interview, especially if the relative is either a child or a spouse. Most other relatives are not always scheduled, especially if they're outside the US. The USCIS will go ahead and process the application or the relative petition without an interview. If there is an interview, usually marriage interview, the parties will sit before an immigration officer who will then ask questions to ascertain how well they know each other and to ascertain whether this marriage is bona fide and not entered into solely for the purpose of conferring lawful permanent resident status. So the parties will be asked, for example, how they met, how their home looks, and then their answers would be compared. If someone is a spouse of a US citizen or permanent resident and the marriage is not yet 2 years old at the time that person receives their green card, the person becomes a conditional lawful permanent resident, and their green card will be valid for only 2 years. And then 90 days prior to that 2-year anniversary, the applicant would have to apply to remove the conditions on their green card so that they can then have an unrestricted lawful permanent resident status. Divorce affects conditional residency in that if you are no longer divorced on the 2nd anniversary of your conditional residence, you then must either apply for a waiver or you would lose your green card status. Divorce has no effect on the affidavit of support. In order to petition for a family member, the petitioning relative must submit an affidavit of support, which is an agreement saying that if this relative that's been sponsored needs assistance from the government, the relative will reimburse the US government for any money spent on that relative that was sponsored. If this is a marriage case and the parties divorce, the affidavit of support requirements remain until the sponsored person becomes a US citizen or has worked for 10 years and can be credited with 10 years or 40 quarters of Social Security earnings, or the person perishes and dies. That is the only time, but divorce does not terminate the requirement to support a spouse. All marriages and all claimed relationships are investigated to make sure it's not fraudulent and that the marriage is bona fide, and no money has been paid for the petitioning relative to put in the application. If you are found to have engaged in fraud, you're barred from ever getting a green card forever. You can also face jail time and some pretty hefty fines, about $250,000. The next category is employer sponsorship. So being sponsored by an employer can lead to an immigrant visa. There are 4 employer-sponsored categories. There's EB1, which is for extraordinary ability persons. Then there's EB2, advanced degree exceptional ability. EB3 is for persons with a bachelor's degree or no degree or an associate's degree. And EB4 is special immigrants, religious-based immigrants. Now, even though EB1 is usually considered extraordinary, there are additional categories that fall under EB1. So EB1 is the first preference. They're priority workers. It is for persons with extraordinary ability in the sciences, arts, education, business, or athletics. It's for outstanding professors and researchers, or certain multinational managers and executives. You need an employer to petition for you if you're an outstanding professor, researcher, or multinational manager and executives. However, you do not need an employer if you're in the first preference, but we will discuss that a little bit later when we talk about self-sponsoring without an employer. The second category of employment-based visas are for members of the professions holding advanced degrees or for persons with exceptional ability. Note, first preference is extraordinary ability. Second preference is exceptional ability. Third preference is for skilled workers, professionals who do not have an advanced degree, and other workers. As I discussed before, persons who may not have a degree or may have less than a bachelor's degree. For the third preference category, you do need labor certification. You need an employer to petition for you. It's called Perm Process. It involves advertising, the employer advertising the position and engaging in a meaningful recruitment process, which means when the position is advertised, anyone who response has to be interviewed, or the employer has to have a lawful reason for rejecting that person. After the recruitment, the employer submits the labor certification application. And if the Department of Labor agrees that the employer could not find any qualified candidates for the position, then the labor certification application is certified. If the Department of Labor is not satisfied that the employer engaged in meaningful recruitment, the Department of Labor can order the employer to engage in supervised recruitment so that the Department of Labor too can see what kinds of applications are being submitted in response to the job advertisement. The employer then files the petition with USCIS, which is called Petition for Alien Employee. It's a Form I-140. That is filed after the labor certification is granted. Most of the time, the focus of USCIS is on the ability of the employer to pay and whether there is a bona fide position that exists. It has to be bona fide, and the position has to be a permanent one. Once USCIS approves the employer petition, it means the employee can apply for lawful permanent resident status. So that is how you obtain resident status, through employer petitions. The benefits of labor certification. If you have an H-1B visa and your labor certification has been pending for 365 days, and you're at the end of your H-1B 6-year period, you can extend it beyond year 6. This is especially important and useful for those who are from countries where there is a long wait for their priority date to become current and for them to apply to adjust their status. If you are an H-1B and you have your spouse who has H-4 employment, who is seeking H-4 employment authorization, that spouse can apply for a work permit if your application has been pending 365 days or the employer petition has been approved. There are within the employment-based categories, there are some categories that allow for self-sponsorship, meaning no employer is needed. The first is the EB-1, extraordinary ability persons, and you do not need an employer. You do need to provide evidence that you are extraordinarily abled. So some of this evidence would be prizes or awards, membership in associations that require outstanding achievements, say someone inducted into a prestigious honor society that requires certain achievements in order to become a member. Usually this would not include memberships that you pay for and that is awarded upon the payment of fees. You need to show that you have published in professional peer-reviewed trade journals, or that you've served as a judge of the work of others because you're so good in your field, or that you've made significant contributions to your field. And this can take many forms. It can be articles, the same publications. It could be research. It's very specific to the applicant. There's no one formula. USCIS lists 10 criteria and sample of evidence that can be submitted, and they require at least 3 out of the 10. Usually extraordinary ability is the cream of the crop, the 1% of those who are so extraordinarily able that they command significant respect in their field. This is usually someone who has been working in the area of their profession, but that does not mean that someone graduating with a PhD or a master's would not be able to meet the criteria. The next criteria is available for EB2 applicants who possess an advanced degree. With the national interest waiver, you're asking the government to waive the perm or labor certification process because your obtaining lawful permanent residence would be beneficial to the United States, such that there is no need for the labor certification. The proposed endeavor must have both substantial merit and national importance. This means if this is something the US will value, that will assist the US, if it'll help the US address a problem that the country faces as a whole on a national level. There is no specific field that you need to major in order to apply for this. But you do need to show that you're well positioned to advance the proposed endeavor, meaning you can't say, I'm basing my application for the national interest waiver on a chemistry project and then have a degree only in biology, for example. So your educational achievements need to match or qualify you for this proposed endeavor. Also, if you get the green card saying that you want to work in a specific field, it is a good idea to continue to work in that field, because if you do not and you apply for citizenship, USCIS can discover that you did not work in the field, and you could be accused of misrepresentation or fraud in the obtaining of the permanent resident status through the national interest waiver. Again, employer petition is not required, no labor certification is required. Usually though, you want an interested government agency to state that your work is beneficial to them. Again, this is not a bright line rule. It just depends on what you're doing. If you've worked for a government agency, maybe the agency in its official capacity may not write a letter, but your supervisor who works with the agency could. Usually letters in support are recommended from persons who are in the field, who can say what the impact of your work, your research, your project is on the field or will be in the future. Another way through the employment base to get an immigrant visa is through investment. This is the EB-5 project or program. You need to invest $1 million into the US economy. In areas of poverty, you can get away with investing only $500,000. You do need to have the area designated though as one in which the $500,000 investment would qualify you. Your project or investment has to create jobs for at least 10 US workers. The investor gets conditional residency for 2 years, and after 2 years needs to apply to remove the conditions on the residency by showing that the investment continues to create the jobs mentioned, and the investor is still fully invested. The money invested has to be at risk, meaning you can't say, well, I'm going to keep this money in the bank, but I intend for it to be my investment. It has to be at risk. It has to actually be invested. There are projects that will just allow people to pay $1 million and they will put it towards that project. For example, Live Casino was one of those projects where if you paid into it, you got the paperwork needed to apply for your EB-5 investment green card. Are there, well, since we have a little bit of time, I will ask you to ask your questions, and then I'll move on into the other questions that were submitted.
I have a question.
Yes.
So you mentioned, especially with this EB2, that there's a requirement or preference for if an agency can make a letter saying that the skills, the important skills will be useful in the field or for U.S. interests. That is assuming the person who's applying is already here and already working in a project, or could that be applied for someone that is abroad and is trying to get sponsored?
Well, it depends on the project, but if you're abroad, it would, you may not be able to obtain letters in support if no one in the US is familiar. In those instances, your application then would need to clearly demonstrate to the US government how this project or research would benefit the government. I usually suggest that people focus on a particular problem they will be solving, or a particular problem their research or their proposed project can be used to solve. And if they have examples of it having solved a problem in another country, to make it clear.
I have a question.
Yes.
Okay. So as you said about the EB2 visa, so I think this is something which I'll tell my case, so you can tell the answer in general. But I'm working on a county project, Montgomery County public project. If my professor gives me a letter that I have worked in this project, or the county people gives a letter, can I apply for EB2 visa?
Without knowing more about your background and accomplishments, meaning, do you have an advanced degree? Are you going through an employer, or you're applying for a national interest waiver? If you're applying for, were you saying that question in the context of applying for a national interest waiver or having an employer petition?
It's like waiver for a national employer. Like I don't have an employer, but if I wanted to apply by my own, the EB2
Okay.
visa with
Yes.
application.
Yeah. Okay, so in instances where you're working for county government, you do want letters in support, and yes, it can be from someone at a county. But again, remember, you're saying that whatever your proposed skill set, program, project is, it will solve a problem for the US on a national level, not just a state or county wide level. So as I stated before, you need to think, what will your, what problem will your immigration solve for the United States? What research do you have? What program that you work on, and how will that solve a national problem? So it's just not, it's not only a matter of people writing, it's a matter of what the project is.
Okay, actually my project is based on what the county people have came into a bill for the pesticide ban, which is actually a national thing in US. So that's the reason I'm like asking you. My project is based on organic management, which is kind of related to the climate change. So that's the reason for me to ask this question. If my professor who is guiding me, or the county people who say that she actually worked in this project and she's the only one who did it, can I, like without any employer, I can apply for the EB2 visa? Like that's my question.
If you get letters verifying that you have work, that you're qualified to advance this project. And you also, though, need to articulate in such an application how you will bring this project to benefit on a national level. Will you be continuing to work for a particular agency? You need to have a plan of what you plan to do once you become a lawful permanent resident. So the reason the national interest waiver was created was to allow government agencies to be able to retain top talent, even though U.S. government agencies cannot file sponsorship applications for employees. So if, say, you would be continuing to work for the county, that would be fine. Or I would link that to the national level. And like you said, you just identified the problem that such research would address. It's climate change, it's the pesticide ban. Some people are already working in areas where they're sharing this knowledge. So if this is something, like, would you be consulting? Would you be sharing it? You do need to make it clear that you're not only applying based on past accomplishments, but that once you are let in as a permanent resident, you will be benefiting the U.S. prospectively.
So this is just a follow-up question to my question. So if I apply for the lawful permanent resident based on my project, so I need to work only in that kind of like pesticide ban thing only in my future, or?
Well, as I stated during my presentation, if you get a green card saying you're going to work in a specific field, it's probably best to continue, because otherwise you could be accused of having applied for the green card and misrepresenting yourself. Now, if your pesticides, say you do work in pesticides for 3-4 years, and then you branch into something else that is related, it may not be a problem. But you can't say you're coming to work on pesticides and then move on to a completely unrelated field. And I know you have a lot of questions, but I do need to get to the other
right.
questions.
Sure. Sorry about that. Thank you.
That's quite all right. We're glad that Patricia's here to help. Patricia, I have several questions to read to you. The first one is, can we get a K-1 visa with work authorization earlier if the green card waiting time is high?
Well, that question requires a little bit of context. K-1 is available to persons who are outside of the U.S. and who are fiancés of a U.S. citizen. Persons who are married to a U.S. citizen and who is still outside the U.S. can come to the U.S. after the U.S. citizen files a relative petition. They can apply for a K-3 visa. And people routinely do that because the I-130 processing times are quite long. So I'm not sure if that's the question the person was asking or not. But K-1 fiancés are eligible for a work permit. And when the K-1 comes into the US, they have to get married within 90 days. So once they're married, they can file to adjust their status and apply for a work permit that way as well.
All right, thank you. All right, next question. Is it possible for an F1 student who filed 1485 to work under CPT?
Okay, I think they might mean a 485, which is the application, the form number for the application to adjust status.
Yes.
If you have applied to adjust your status, you can obtain a work permit that way. Once you apply to adjust your status, you're no longer maintaining your student status, and curricular practical training, which is CPT, is part of your F1 visa. It's one of the benefits of an F1 visa. So if you have applied for adjustment of status, you need to just apply for a work permit to be able to work that way. Because once you apply to remain in the US permanently, you're contradicting the non-immigrant intent that you had to have, or you have to have, in order to maintain student status.
Okay, great. Next question is, for an EB1 self-sponsored application, do only first authored publications count? Do co-authored papers also count?
Well, co-authored papers would count, But in order to demonstrate that you are at a certain level, you want to show individual work. So I would not submit only co-authored papers, in that it's quite difficult to know who wrote what portion.
Okay. Next question. Is it possible for an F1 to apply the 2023 Diversity Immigrant Visa Program?
Yes, an F1 can apply. It's a lottery. It's not certain that you will get it. It's a little different than applying to adjust your status or having someone apply for an immigrant visa for you, which is more certain. You may not be selected, if you play the diversity lottery. So it's not, it's a game of chance.
Okay, next question. Are there other kinds of EB2 besides NIW? I only have an advanced degree, but I'm not sure if I'm qualified for national interest.
Yes, EB2 includes professionals with an advanced degree and exceptional ability persons. Both categories, if you have an employer who can petition for you, the employer will petition. The benefit of the EB1, EB2, EB3, EB4 is that the EB1s usually have no wait. EB2s have a shorter wait, if one at all. So you can still take advantage of that classification to get you a visa quicker than, say, compared to the EB3 or other worker category.
Quick question building up on that. Is there any difference made between advanced degrees, like a master versus a PhD? Does that give a weight to the application, or and are
No.
both qualified equally to enable application?
Yeah, it simply says for EB2, advanced degree professionals. Whereas usually for EB1, included under that category is the outstanding professors, and most professors need a PhD. So, but for purposes of the EB2, master's or PhD would count.
Okay, thank you.
All right, next question. For EB1, EB2, how many citations for research publications are needed so that the profile is considered strong?
There is no set number. I get this question a lot. There is no set number, but among the citations, if I would say, if you're cited 100 times as, say, the fourth article in a string of cites, it's not as strong as being the primary cite in 100 different papers. And hopefully that was clear. So it's not so much about quantity, it's about quality. The quality of the citations to you. Who is citing to you, and is it other known people in the field that are relying on your work, or is it, say, a lot of student theses that are citing to you? And that's not to say being cited in a student thesis or dissertation, it's a bad thing or makes it weighed less, but you're trying to show that you are substantially contributing to your field. So when other leaders in the field are citing to you, it shows that you're substantially contributing. And keep in mind that for purposes of these visa categories, one type of proof could do more than one thing. It could prove more than one aspect of your case.
Okay, thank you, Patricia. Next question. Can someone apply for a green card through multiple categories? For example, can someone apply for both an EB2, NIW, and an EB1-B?
That is correct. The way the US government works, or the US visa program works, you can apply for as many avenues that lead to a green card. It's just that you cannot apply for a green card once you already have one. So someone in that situation would apply, and then the first one that comes through, they would just withdraw the other applications.
All right, thank you. Is it possible for a J1 visa holder to apply for the 2023 Diversity Immigration Visa Program?
Well, it is possible to apply. However, if your J1 visa has a 2-year homestay requirement to it, and you apply, you may not be able to obtain that green card unless you obtain a waiver of the 2-year homestay. So you're running a risk of winning and then not being able to get the visa because you haven't fulfilled your 2-year homestay on the J visa if it's required.
I think you already answered to that questions, but I'm sorry, I missed that part. So can F1 students, like I'm F1 student, can I apply for EB1 or EB2 right now? Because I think I have enough publications, so I just want to try. And then also to diversity program.
Okay, anyone can apply to the diversity visa who has 2 years of college. So that would work. EB2, you need to have an advanced degree, even if you're applying for the national interest waiver. So hopefully that answers your question. If you feel, that your becoming a permanent resident would benefit the US on the national level in a substantial way, you would make your case and apply. What was the other question about a PhD?
I have a master's degree, but I'm just right now I'm doing PhD. I'm going to advance to candidacy like in a month. So I was wondering, after advancing to candidacy, and then we also collaborate with NIH and NIST. So if I can get letters from my PIs from that institutions and from my advisors, I have a couple advisors. I was thinking maybe I can try my chance.
Well, yeah, I was going to say you have to make your case. So if you feel you can make your case, then you make your case. All that's required is an advanced degree, not a PhD. And for the EB1, you need to be an extraordinary ability person. So
No.
that's what's
Yeah. But I remember, like you mentioned that if you are right now, if you're a student, F1 student, and if you apply for a green card, you are so according to F1, you can stay in the United States. The purpose of staying is just to study, just to come to get an education. So will it violate that rule, or is it fine to still apply?
Well, you have to understand that once you start applying, you can't go back. So you may have difficulty when you apply for OPT, for example, because you already have a pending immigrant visa application.
I see.
Yeah.
Okay.
Yeah. Are there any more questions, Debbie? Because
there is one more.
Okay.
Does the 90-day rule apply for someone who is not in the US within the last 90 days, but first entered the US in F1, say, years ago?
Does the 90-day rule apply? Is this in the chat box? Because it's a very...
It is. Yashiro, could you unmute, please, and clarify your question?
Yeah, hi. I was just wondering if, so there is this 90-day rules according to which one cannot file a form I-485 if the last time he or she entered the United States was 90 days ago.
No, I know what the rule is, but you
okay,
said
sorry.
if the person is not here in the US, so it wouldn't apply.
Oh no, I mean, say in the last 90 days that person at some point was not in the US, and now is in the United States.
Okay,
maybe
the 90-day is counted from date of entry into the US.
I see. So it doesn't matter if, for example, I went away for a vacation, like say in August.
Oh, no, it doesn't. No, because
see.
it's every time you enter at the airport, you're telling the officer, I'm coming in to do the thing that's tied to this visa category.
I see. Okay, I see.
Yeah. All right. And Debbie, you said that was the rest of the questions?
There is one more.
Okay.
All right. How many recommendations do you suggest for EB1 applications? In parentheses, PhD plus 2 years experience. Also, do you want me to read the whole thing or just give it to you in bits?
I was just going to try to answer, so I don't need to remember all of the different questions. Usually I recommend a minimum of 3, but no more than 6. Okay,
that's pretty clear. All right, we've got a few more coming in. We'll just, if you have time, Patricia, we'll stop right at 1:30.
All right, I wanted to try to get to maybe we'll cut off the questions now, and then let's try to get to the ones that are already in there, plus the ones that were written in.
Okay, and before you answer those questions that you got in writing, I just want to remind everyone that if you still have questions, you can request an immigration consultation. Just visit our website, go to the immigration tab. We'll put that in the chat box again, and you can request an appointment. They happen once a month, usually on the second Wednesday of the month. All right, Patricia, take it away.
Okay, you said there was one last question?
Yeah, there's a few more in here. I could do the next one.
Yeah.
Okay, so if I apply for the green card and it takes longer than expected to approve, and meanwhile my visa expires, what should I do? Is this going to impact my non-immigration visa application?
Okay. I'm not sure which visa the person is talking about, but generally, when you apply for a green card, you obtain interim status. You're an adjustment applicant, and so you're not out of status until there is a denial of that application. If the application is approved, you were never out of status.
Okay.
All
Very
right.
good.
Okay.
Do you want, so there are more questions coming in, but I know you can get to some of the ones in writing.
Yeah, so let me get to the ones in writing.
Okay.
So one question was how to frame the time for receiving a green card. I think what this person wants to know is how long will it take? What is the time frame? There are processing times posted on uscis.gov, the website, and you can check because the answer depends on which office has your green card, etc. If it's been more than 120 days, which they indicate has been for the past 4 months, you can always call customer service at USCIS or put in an e-inquiry online to see what's happening. What green cards are taking, they can take now about up to 2.5 years. The naturalization requirements, you do need to be a permanent resident for 5 years in general. Those who obtain permanent residency through a US citizen and continue to be married to one can naturalize after 3 years. You can file your application 3 months ahead of time, so after 4 years and 9 months, or 2 years and 9 months. You do need to speak, read, and write English and understand English. It's not extremely difficult to pass or to meet that requirement if you're attending school and being instructed in English. So that should not be an issue. You apply for a green card after getting married. What's the time frame? Again, it depends on which state you reside in. And you can always check that online at the USCIS website. And how quickly are you able to work and stop depending on your previous employer-sponsored visa? You can work when you receive your work permit if you applied for one. If you did not, you'll need to apply for one, and it can take between 6 to 8 months to receive a work permit. Can a PhD student who's received an international award apply for a green card? I've already answered. F1 with permanent resident pending, apply for OPT. There could be potential problems because you've already applied for permanent resident status, as I indicated. Can an F1 student or OPT apply for permanent resident status? You can, because after your OPT end, you won't have any more statuses. And if you probably won't be renewing the OPT. So yes, you can at that point. What is the expected time to get a green card through EB1 after PhD? Again, that just depends. You can always check on it. What is the best way to expedite the process? Working in academia may be helpful if you can qualify as an outstanding professor or researcher, but EB1 is a priority category. Usually it doesn't take that long to get the green card. It should be one of the shorter categories unless you're from one of the backlogged countries. And get a green card through national interest waiver. Can you have a PhD in engineering? Is that the only, do you only work for an engineering company? Well, it depends on what you got the national interest waiver for. If that project can be used by other non-engineering companies, then you can work for, you can work in any area that would further the national benefit that you're supposed to be conferring on the US. What are the requirements to file for a green card for a PhD? I already answered that, and whether there's a certain number. Okay, Debbie, do you want to go back to the questions that came in?
That'd be great if you have time.
Yes, yes.
Fantastic. All right. So if someone self-sponsored for EB-NIW and it gets rejected, then does it affect future chances of getting the H-1B permit? Also, no. Okay. So also, can the person again apply for green card in the future through a different category, such as EB2 or EB1?
They can.
All right, that's good news.
Yes, yes.
How many years is the EB2 advanced degree waiting time after submitting the application?
Well, the EB2 application can vary. There are several, it depends on whether the employer is petitioning for labor certification, on whether it's self-sponsorship. So it can vary. It's longer, obviously, if the employer is petitioning for labor certification, because you have to go to the Department of Labor first, then the employer files the I-140 before the person can then apply for adjustment of status.
All right. Thank you, Patricia. There are 2 more questions, and those will be the last 2 we'll take.
Okay, all right.
Can you apply for EB1 or, oh, I just asked that, I'm sorry. Okay, I have a question about, another question about the 90-day rule. According to the Foreign Affairs Manual, it's not sufficient for an F1 visa student to apply for adjustment of status within 90 days to assume a willful misrepresentation The person must engage in an activity inconsistent with F1 without the benefit of new status. Can you elaborate on what will actually constitute the willful misrepresentation?
Well, willful misrepresentation would be someone who gets a student visa, comes in, maybe does not take a full-time load for their program of study, applies for or gets married immediately and applies for adjustment of status. Acting inconsistent, in a sense, is almost like circumstantial evidence that you had no intentions of being a full-time non-immigrant student.
All right. I think that's it for the questions.
Okay.
I'm so sorry that we're out of time. And Patricia, you've been very generous. Thank you for going over the allotted time. We appreciate you so much. And you're just such a wealth of information. And I know you well enough to know that you really have the students' best interests at heart. So thank you for your kindness and your generosity.
Okay, thank you, Debbie. It's good to see you again.
Thank you to all the students that joined us today. Remember to do the 6-second survey. It only takes 6 seconds. And next week's workshop is on buying a car and how to take care of it. So everyone, have a great week and let us know at Legal Aid how we can help you. Bye-bye.